Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast. I'm one of your hosts, Marcy Dixon. On today's show, we have Miles Neutral's Jennifer Grippa and Steve McKinney. Jennifer and Steve specialize in complex ADR and bring significant expertise and value to their clients at Miles. Today, Steve and Jennifer will be discussing ways to realize economy and expedition in the arbitration process. ADR, as currently practiced, too often mutates into a private judicial system that looks and costs like the litigation it's supposed to prevent. At many companies, ADR procedures now typically include a lot of excess baggage in the form of motions, briefs, discovery, judges, lawyers, court reporters, publicity, and damage awards that are far beyond reason and beyond contractual limits. Much to the detriment of disputing parties, arbitration has become less and less of an alternative to litigation. Jennifer and Steve, what are your thoughts on all of this?
I think arbitration was initially created to provide an alternative to litigation that would be faster, more efficient, more economical for the parties to resolve their dispute. And over time, some litigators have kind of run with arbitration and turned it into more of a miniature litigation, litigation light, if you will. And so I have seen instances where arbitrations have become more and more expensive, costing hundreds of thousands of dollars in legal fees to get through an arbitration hearing. And I think people have become a little discouraged with the process and are not realizing the economies and efficiencies that arbitration was intended to provide. And so I think that's a challenge that arbitration has seen, and I think it's important for arbitrators to be mindful of that and to provide ways to really put the alternative back into alternative dispute resolution and bring arbitration back to what it was initially intended to be.
Jennifer, I find that that's especially important in the context of arbitration because unlike other forms of alternative dispute resolution, in arbitration, the parties themselves have decided way back even before the dispute began, at the time that they entered into an agreement that included an arbitration clause, they've already decided that they want to realize economy and expedition and take control of how any disputes under the agreement are going to be resolved. And given the fact that even before advocates are hired to help the parties resolve the dispute in arbitration, the parties have already made a decision to realize that economy and expedition. The advocates that are hired, even though they might typically be consider themselves litigators and operate under rules of civil procedure, really, it seems to me, need to take seriously their role as an arbitration advocate as distinct from being a litigator. What do I mean by arbitration advocate? I mean an advocate for a party in arbitration who is going to understand that arbitration isn't, as you just described it, litigation light, but it instead is a choice made by parties to try to resolve a dispute in a way where they are in control of the rules. And I think this takes many forms, but I think that the place where it all begins and makes the most difference is at the initial arbitration conference. At the initial arbitration conference, the parties still have the ability to take stock of the particular size and shape and scope and value of the dispute and make decisions about how they're going to plan the preparation for the arbitration hearing, how they're going to do discovery, to what degree they're going to do discovery. And I think that's the time for the arbitration advocates to put on their arbitration advocate hat and begin to help their clients, along with the arbitrator, realize this economy and an expedition in resolving the dispute.
And I think it's important for the arbitrator to be mindful of the fact that the process was intended, and as you say, the parties have elected to have their dispute resolved in a more efficient manner. It's important for the neutral to really be mindful of that and to encourage the advocates and the parties in that process to be mindful that this is arbitration and not litigation, and to participate in that initial conference and to make decisions and to plan for the arbitration in a manner that is going to recognize those efficiencies.
Jennifer, one of the ways that I find when I serve as an arbitrator that the arbitration gets off track early on by the advocates not thinking of themselves as arbitration advocates, but thinking strictly in terms of litigation, is something that I have called the subpoena mystique, that advocates in arbitration oftentimes will take for granted that as an arbitrator, I have the power to sign a piece of paper that they present to me that has at the top subpoena, and that somehow or another that's exactly like getting a judge to sign a subpoena or they're signing a subpoena under the Federal Rules of Civil Procedure. And the reason I see that as a problem as an arbitrator is that I've got to be, if I'm really going to help the parties realize their goals of realizing some kind of economy and expedition, I've got to be transparent with the advocates and with the parties that I don't have subpoena power. What a subpoena is, as you know, is a court order. And we're not in court, and I'm not a judge. I don't have a police force or any kind of judicial officer or any kind of officer that I can use to enforce any kind of subpoena or any other kind of directive that I might sign as an arbitrator. And while the Federal Arbitration Act and state arbitration acts do provide the parties with ways in which to take directives that I might sign and take those to court and have them turned into court orders, which can then be enforced the way a subpoena would in litigation. They need to understand that the process in arbitration simply doesn't allow for the kind of efficient enforcement of those directives as you get in litigation. Well, if that's the case, then that dictates that you're going to have to plan ahead way in advance if you're going to realize any economy and expedition. If you've got documents you need from third parties, if you have witnesses that need to testify in deposition or need to testify at a hearing, you can't simply anticipate that they're going to respond to something that I, as the arbitrator, sign because I'm not in a position with any efficiency to enforce that. In fact, if it has to be enforced, you're going to have to go get a court to do that. Well, given that, at the initial arbitration conference, that's the time, and even before that, to put on your arbitrator advocate hat and realize you're going to have to collaborate with opposing counsel. Are the witnesses that you want to compel to participate folks that your opposing counsel can help you or can help encourage them to participate as a witness? Are they employees or otherwise in the control of the opposing counsel or the opposing party so that they could help procure that witness testimony? Can you make that happen by returning the favor and by collaborating and making witnesses that are otherwise complicated for your opposing counsel available? All of these things take planning and collaboration. You certainly could still have witnesses who do not want to participate and will not participate without being compelled to do so. Well, in those situations, you're simply going to have to acknowledge that any directive I could sign is going to have to be enforced by a court. You're going to want to do that early. So many times anymore in arbitrations, I have arbitration advocates coming to me, asking me to sign directives. I'm very reluctant to sign anything that's called a subpoena because anything that I sign isn't a court order. They come right before the hearing or they come right before they need the proof, and they expect, as in litigation, for folks to simply line up and cooperate in participating as they would if they were in receipt of an actual court order. Well, I'll sign directives if they want, but they need to understand that they're just going to run into heartache and headache and expense unless they acknowledge right up front that because we're in arbitration, you just have to do things differently. You have to operate anticipating things well in advance. You have to operate with the understanding that there's limitations on what the arbitrator can do with any efficiency to help you get your proof together. Likewise, I find that acknowledging those limitations can also be the key to taking charge of the dispute and actually collaborating with your opposing counsel. Your opposing counsel is working under the same limitations that you are. And if you'll acknowledge that, you won't really have to live with the sense that you're missing out on something or you're operating under some disability that is unfairly impinging your client's ability to put a case together.
Right. Neither party in arbitration wants to run out and have to go get a subpoena in court to enforce that, to get a recalcitrant witness to show up, especially when the other side has the power to get them there.
Yeah, and I think you'd agree that that sort of defeats the purpose. That
Exactly.
if by failing, by inattention or just by not being very sophisticated in how to be an arbitration advocate, you just assume that this operates the exact same way that litigation does, you're going to run afoul of all kinds of inefficiencies. You're going to run afoul of all kinds of time waste. You're going to run afoul of all kinds of expense, the very thing that your client decided before they ever hired you that they wanted to avoid because you're in arbitration.
And that's one of the things I've seen. One of the challenges that have developed over time with arbitration is the depth of discovery that people are doing in arbitration, and really just handling the arbitration as if it is litigation, and it's really not.
Yeah. Jennifer, one of the things that I try to communicate to parties in advance of the initial arbitration hearing that helps them focus on that, and I hope will try to empower them to understand that arbitration offers them an excellent opportunity to realize economy and expedition. I point out three things in writing to them before they ever get to the initial arbitration conference. The first thing I point out is that they're not bound strictly by the arbitration clause that caused the arbitration to get underway. If both parties are headed to an initial arbitration conference, that means they've either agreed to arbitrate or one of the other parties has agreed that they're not going to try to undo the arbitration clause or get a ruling that the arbitration clause is not enforceable. So the arbitration clause has already served the purpose of causing the arbitration to take place. Once that has happened, the parties don't need to feel like the arbitration clause is just a substitute for the rules of civil procedure, that it's some kind of predetermined set of rules and boundaries and impingements that they're having to put in their knapsack and carry with them into arbitration. It seems to me, as the arbitrator, what they need to be prompted to think about and to do in order to realize this economy and expedition is that they're still free to take a look at the particular dispute they're getting ready to arbitrate, its size, its shape, its value to them, its dollar value potentially, and make decisions about how they want to arbitrate it. They can dispense with rules that are referenced in the arbitration clause if the parties agree to do that. They can use part of those rules and leave part of those rules behind. They can make decisions about the scope of discovery. They can make all kinds of decisions, and in fact, they need to make those decisions rather than simply showing up at the initial arbitration conference with the arbitration clause in their vest pocket and thinking that, well, this somehow or another, they shrug their shoulders and say, well, we're bound by this. There's really nothing for us to do. What I encourage, first and foremost, is for them to understand there's everything for you to do because anything is possible if both parties agree to it. The second thing I encourage them to do in advance of the initial arbitration conference is to plan on having a decision maker from the party appear at the initial arbitration conference with the arbitration advocate.
I think that's a great idea because it really brings those company representatives, those decision makers into the case and really gets them involved in the process, and they can have a role in creating what the arbitration process is going to look like based on their dispute.
And I think that's an appropriate time to remind them as parties that they've already made this decision and that they're not bound. I find so much certainly in litigation, but even in arbitration and in other forms of alternative dispute resolutions, instead of empowering parties oftentimes are just sort of drug along. They don't understand the process. They don't really feel empowered to take charge of the dispute. I think an initial arbitration conference is the perfect time for parties to be present and attending and to understand that this is their chance to go ahead and realize on the potential that they've created by doing the arbitration clause to begin with.
I don't think a lot of litigators bring their clients to that initial arbitration conference or have them participate in that preliminary hearing, if you will, even if it's by telephone. But I do think that it would be helpful for them to do that and to really engage their client early on in the process. And I think that would help them to explain to their clients why they may be doing less discovery in the case. Because it's easy for clients to second guess the lawyer later and say, why do we not know about this evidence that was coming in, or why didn't we depose this witness before they testified in the arbitration proceeding? And you could, as a litigator, take a scorched earth policy and do tons of discovery and leave every stone unturned and depose everyone, but really you might as well do that in litigation and not arbitration.
Jennifer, that falls into the third thing that I try to accomplish in writing to the parties and their advocates in advance of the initial arbitration conference. And that is to remind them or at least plant a seed around something that I have come to call the 60% solution. I tried cases and was an advocate in mediation and arbitration for private parties for 30 years. At the same time that I was also serving as a neutral, as an arbitrator and a mediator. And across that 30 years, what I found pretty consistently, and I tried cases all over the country in state court and federal court, is that no matter how much discovery was done, and sometimes I was involved in matters where discovery rolled into third and fourth years, was just dizzying the amount of discovery that was taking place before we ever got to anything like a hearing or a trial. That no matter how much discovery was done, really and truly, in preparing for an arbitration hearing or in preparing for a trial, only about 60% of everything that was discovered is brought to bear in putting a case together. And then when you account for the ways in which the court exercises its authority to exclude evidence and to shape the proof that's put in, by the time you're done with a hearing or by the time you're done with a trial, vastly less than that 60% actually gets into the trial record. What arbitration creates is an opportunity for the parties to be transparent and honest with themselves about this 60% rule, in that they can understand that they don't have to turn over every rock, that they can take a hard look at this particular dispute, its size, shape, its scope, the dollar value of the dispute, and they can make reasoned decisions about asking for, looking for, gathering something less than 100% of everything that they might anticipate is out there. Is that risky? Yeah, it is a risk to go into a hearing feeling like you have done everything to pare down and to be more efficient about what kind of proof you're going to gather. But your opposing counsel, if you agree to rules like that, is operating under exactly the same terms as you are. And all you're doing together is making a decision that you're going to realize economy and expedition by trying to shape the information gathering phase, the discovery phase, if you will, to the size and scope of the dispute. That's the place I find, and I think you might have as well, where the horse can run away with a cart from a cost and a time standpoint. Absolutely. I had an advocate tell me over lunch the other day that he had just gotten back that morning from an initial arbitration conference at which an agreement was struck. He said without a great deal of thought or forethought on the part of the parties or the arbitrator, that 20 depositions aside were going to be taken, and an arbitration hearing was set for 3 years after the arbitration conference. Now, Jennifer, I don't know that particular dispute. I don't have any way to judge whether or not that dispute really requires that amount of discovery and lead time before a hearing. I will tell you that one of the advocates in that case who I was having lunch with was highly suspicious that with 20 depositions and with 3 years allowed in putting discovery together, that there was going to be any economy realized relative to the value of the dispute. That's the kind of thing that I think parties need to be encouraged to understand, not just by their advocates, their arbitration advocates, but also in my role as the neutral, as the arbitrator, encouraged to understand that this is your chance. You've already decided to do arbitration instead of litigate. This is your chance to realize on your intention to really realize some economy and some expedition in doing the planning for discovery.
And I think advocates in arbitration need to be mindful that their clients are going to benefit from the limitations on discovery as well, not just thinking about it from how am I going to be limited in the discovery that I'm going to do, but also what you're limiting the other side from doing. And sometimes that can be very important to your client in an arbitration to really prevent the other side from running away, like the horse getting away from the cart, because depending upon the situation, depending upon the case, depending upon, frankly, who the other side is and who their lawyer is. I mean, you might have a totally different result if a different litigator is on the other side of the case. And depending on what their take is on the arbitration, how they're going to handle it, it can be very beneficial to really come up with some limits ahead of time to spare the parties time and expense, which is really what arbitration was intended to provide in the first place.
Jennifer, changing gears just a little bit, what's your experience been with ex parte communications in the context of arbitrations?
I don't think that there should be ex parte communications in the context of arbitrations. I think it's completely different than mediation. As a mediator, I would reach out to both sides, the attorneys for both sides, in advance and to find out what the case is about and figure out a game plan to best help them resolve their dispute voluntarily in mediation. But to me, an arbitrator's role is completely different than a mediator. And they are, as the decision maker, it's very important for them to not have ex parte communications with either side. And I think it's a formal process. I think it should be treated formally. And I think that the arbitrator should be provided information and evidence in the structured format of that arbitration hearing. I don't think that there should be phone calls off the record to the arbitrator in advance about anything. I think that if there are disputes that come up, whether or not somebody needs to be subpoenaed, should be put in writing and copied to the other side, just as litigants would do if they were communicating with a judge. I think it's really no different.
Jennifer, quite ironically, I have found in my role as arbitrator, one of the places where the advocates, I hesitate to say how frequently, but can run afoul of their obligations as an arbitration advocate is in this area of ex parte communications. The irony is that one place that they seem to get off track is by treating the arbitration process no differently than the litigation process in terms of running up expense, not planning ahead, not treating it differently than litigation. But on the flip side of that, ironically, they also run afoul of the over-casual sense that arbitration is, to use the phrase that you used early in our broadcast today, is just litigation light. it's just loosey-goosey form of litigation that has loose time constraints. They don't have to deal with a clerk of court or the judge's secretary or docket pressures. Part of the way in which arbitration advocates can suffer as a result of that sort of loosey-goosey sense of or soft and mushy sense of arbitration just being a mushy or a light form of litigation is being over casual about trying to communicate with the arbitrator and seeking this ex parte communication, not necessarily out of a sense of trying to be unfair to their opposing counsel, but out of an inattentive sense that, well, there aren't really rules that apply here in the same sort of strict way that they do in litigation. And so I'm going to go over the transom. I'm going to sort of seek some guidance on some merits issue. And the arbitrator ought to return my call or ought to engage me because we're not in litigation. That creates real problems because the arbitrator, in order to be the kind of neutral the arbitrator is, has to be free from ex parte inputs from either party. Jennifer, one last thing that I tend to do, and I find that other Miles arbitrators tend to do, that serves the purpose of maintaining the values that are inherent in alternative dispute resolution, which is the parties having and taking charge of their own dispute and how it's going to be resolved, is that as an arbitrator at the initial arbitration conference, I make absolutely clear to the parties that, in my view, summary adjudication can be a very important part of arbitration. There are both parties and arbitrators who really take a dim view of a party seeking to have a summary adjudication, what would be equivalent in litigation to a summary judgment motion, where the arbitrator is asked, based on the record that's been developed, to make an award or a ruling without a hearing. The same rules, as far as I'm concerned, apply to an arbitrator's entertaining such a motion, in that if the arbitrator determines that there really hasn't been any proof generated that negatives the position taken by the party who is making a claim in arbitration, and it appears that they're entitled to an award just based on the evidence that's been generated, I think an arbitrator is really doing an injustice to ADR, is doing injustice to arbitration, and ultimately doing an injustice to the party if she or he doesn't entertain those summary adjudication motions and give a serious effort at granting those where they're appropriate, even if the upshot is that there isn't any arbitration hearing. I understand as an arbitrator that it could be that the place in which I realize my largest amount of remuneration in an arbitration is by having a hearing or even a lengthy hearing. But I don't feel like that sort of interest on my part as an arbitrator in any way ought to infect my entertaining at an appropriate time and in an appropriate way an effort on a party's part to get a summary adjudication where it's appropriate. Anything that can be adjudicated, anything that can be resolved by an award without there having to be a hearing, absolutely goes right to the heart of the ADR process. And it goes right to the heart of the parties already having decided that they want to operate with economy and expedition. And so at the initial arbitration conference, I explicitly let the parties know that that's not only not frowned upon, but that's something that's encouraged where it's appropriate, because that's entirely in keeping with the parties' efforts at trying to work expeditiously and as inexpensively as possible to reach a resolution.
I agree. I think that it's important to for the parties to discuss that up front and determine whether there will be summary judgment motions and whether those will be provided and the arbitrator to rule on those. And I think that if the law provides for that particular issue to be adjudicated on summary judgment, then the arbitrator should rule according to that. I think a lot of litigators have come to think that everything's just going to be decided at arbitration at the final hearing. And a lot of litigators have, just seen too many arbitrators split the baby and not actually follow the law. And I think that's given arbitration a bad rap. And arbitrators have to take very seriously their role as the arbitrator to follow the law and to grant summary adjudication where it's appropriate, and to, again, follow the law in the award.
Jennifer and Steve, thank you so much for your perspectives on the inherent deficiencies in the arbitration process and for providing insights on how litigants and attorneys can use it as an effective tool for dispute resolution. Thanks so much for being here today.
Well, Marcy, thanks for having us. We enjoyed it.
Yes, thanks for giving us an opportunity to talk about this topic, and I look forward to talking about more aspects of arbitration as we go forward.
Thank you again for joining us for today's show. On our next segment, we will continue the discussion about arbitration and we'll be joined by Miles Neutral Matt Theory.